There we go. All right, it's 3 o'clock. Welcome, everyone. And I recognize quite a few names, so I'll say welcome in, Wan Ying, bienvenidos, bienvenue, bienvenidi. Welcome to our, I think this is our third seminar regarding the Payroll Protection Program loan. And in particular, what we've been talking a lot about lately is the loan forgiveness. For those of you that are new, my name is Tim Hilligus. I'm a shareholder at Clayton McCurvey, along with one of my partners, Sarah Russell, in our tax department, and Ben Smith, one of our senior managers in our consulting department. We've been working to try to bring as much topical information to the PPP Loan Program as possible. For those of you who've been following this in the news or following our correspondence through our firm's website or through these events on Wednesdays, you know that every day something changes, but you also know there's still quite a bit that's still unanswered. And so hopefully as the days progress, we're going to be able to bring some of that clarification to you as it becomes clearer to us through the Department of Treasury, our legislature, or the SBA itself. So that's kind of the objective here. A little bit about our firm so that those of you who don't know who we are, we're in Southfield, Michigan, and our client base is strictly closely held business entrepreneurs. This is the #1 topic that our clients have been dealing with, frankly, since the end of March, from the day the legislation was created till April 3rd, the first day for the loan applications, April 10th, the second phase of loan applications. You've got stimulus packages 1, 2, 3, and 3.5, and now we may see 4 coming up. So that's a little bit about our firm, and that's what Ben, Sarah, and myself work on every day. Pretty much is those issues related to this legislation, the questions and answers, and some of the interim rules that are coming about. A couple housekeeping items. We are trying to answer questions live in real time, and that could be myself and Ben behind the scenes typing in answers, but also it may very well be that we go ahead and pull your question up and address it directly through the webinar. If you'll notice in the questions, on the right-hand side of each question, there's a little arrow or a little triangle, and if you click on that, it'll help us rank what the most important questions are for each of you. And we'll try to do our best to bring those to the top of bring those to the forefront of the presentation. I can tell you that there's been 2 questions that have already been answered by Ben, and that related to some comments from our prior webinar. And that is, #1, do we have a spreadsheet that we'd make available to you to be able to help prepare your forgiveness calculation? And you'll find, I'm not sure if you're able to search for this, but Denise Asker has asked that question. There should be a link to our website, which will then direct you to a Excel spreadsheet that you'll be able to use. The second one is a link to the Treasury's website to hopefully give you some insight to what Sarah and Ben and myself, and frankly our whole firm, look at when we're determining what changes have occurred. So for example, I think Sarah, you can just nod your head. I think we had a Q&A that happened today, correct? Yeah, so you're gonna have the link to the Treasury Department's resource tools, which for us, that's been primarily the frequently asked questions and the interim final rules related to the PPP Loan Forgiveness Program. The second thing I wanna mention is we're doing these every Wednesday in May at 3 p.m. And we're going to get done at 4. For those of you who remember me from our CFO roundtables, I think you know that we try to really keep your schedules in mind, and that's important. But Sarah, Ben, and myself will stick around and answer as many questions as we can. And we also will be publishing or showing a website for you to revisit the webinar and also see the question and answers that we prepared or completed at the end of the presentation. Now, going back a week ago where we talked about what were we hoping to see within this week, one of the biggest issues was relating to this safe harbor determination. Were you eligible to meet the requirements and certify in a good faith that it was necessary for you to receive these loans? Well, many of you are aware from our last week discussion that the original safe harbor return date was May 7th. They extended that to May 14th, which is tomorrow. So one of the things that the 3 of us were hoping was that we would have some clarification. And unfortunately, right up until now, we haven't got that clarification. What we're asking you to do is consider blocking off your calendar tomorrow at 3 o'clock. If we get some information today or early tomorrow morning, our hope would be to be able to at least provide some insight or at least a first read through on whatever the interim final rules that are going to address what is essentially the Treasury Department's procedures or protocol that they'll use to review and determine if your loan was necessary. So please keep that in mind, that tomorrow at 3 o'clock, the three of us have an open opportunity to possibly address this issue. And if nothing happens, then we'll look possibly for an interim time, but we'd be looking again, of course, to next Wednesday at 3 o'clock. So I think that pretty much, let me just take a quick look. I think that covers all of my my housekeeping items. So let me go ahead and turn this over to Sarah Russell, and Sarah's going to lead our discussion on the latest and greatest related to the Payroll Protection Program loan.
Thanks, Tim. Tim's right. We didn't quite get the guidance that we were hoping to get. However, we did get a little bit of guidance. Today at around 11 o'clock, the Treasury Department issued FAQ 46, which has some pretty good news for some people. The FAQ says that loans with an original principal balance under $2 million will be deemed to meet the required certification standards. There's some language in the FAQ that sort of indicates the SBA is looking at it saying, if you needed a loan of under $2 million, it would be unreasonable for them to think that you had access to other sources of liquidity. So they will deem that that certification standard is met. They also included language in there that indicated it also helps the SBA, as they know that there will be a lot of loans over $2 million that they will need to review, and said it alleviates the burden of going further than that $2 million threshold. That's not to say that no loan under $2 million will be reviewed, but I think in general, you can pretty safely say that if your loan is under $2 million, the general consensus is that that certification will be deemed met. So good news for those of you with loans under $2 million. They also included in the FAQ that for loans over $2 million, last week we talked a lot about, I don't know what the standard means. I know that there's some really onerous punishment if I am deemed not to make that certification in good faith and I don't meet the necessary requirements. I don't know what to do. Should I give the money back? And because they haven't issued guidance before tomorrow, the FAQ says, hey, if the SBA finds that the borrower lacked an adequate basis for that certification, while they will seek repayment of the outstanding loan balance, and they will inform the lender that the borrower is not eligible for loan forgiveness, if the borrower repays the loan after receiving that notification, the SBA will not pursue administrative enforcement or referrals to other agencies based on its determination with respect to that certification. So essentially what they're saying is, hey, if you think that you met that certification, we come through and we review that certification and don't agree with your assessment, we will ask you to repay back the loan, but we will not enforce any criminal action against you. So not the clarification we were hoping for, especially for those loans over $2 million. I think for the loans under $2 million, a lot of people can sleep pretty well tonight knowing that they have in fact made that certification in good faith. But for those loans over $2 million, still a lot of uncertainties are sitting out there. And I think, you know, the next questions we're going to get is, okay, well, I took a loan over $2 million. Should I pay some of it back so that I can, you know, fall underneath that $2 million threshold? There's some key language in the FAQ that talks about an original principal balance. So I think, you know, I think you would need to have a whole new application, right? You need to return the funds you received and then submit another PPP application asking for less than $2 million to fall under this original principal balance threshold that they talk about. I also think that if you really do stand behind your certification, if you've made that in good faith, if you've looked at your business and you can document why you requested the loan balance you did and why you thought it was necessary for your business, whether that's future cash flows, being dragged out longer than normal, whether that's impacting your sales cycle, all of these things that you are probably facing due to the current pandemic. You also don't want to sort of give away your loan forgiveness if indeed you think that you are going to get it. And I think that if you sort of try to claw back and get underneath that $2 million threshold, I think that raises some red flags and, could make it look as if you're trying to skirt a review. And in that instance, may cause even more scrutiny on your good faith certification. So I don't know that we would make that suggestion today. It just doesn't feel like that's the spirit of the law.
So Sarah, we have someone here whose loan must be right on the money. It came in exactly at $2 million. Does $2 million fall in the greater than 2 million or the 2 million or less category?
That's a good question. This is the problem with FAQs. They're written pretty broadly, and at some point they will get turned into interim final guidance, interim final regulations, which will probably have a little bit more meat behind them. But the language just says under $2 million. So I don't know, because the language on the other side says loans over $2 million. So I don't know if you have exactly $2 million, what they'll do.
Yeah, and I think that's an important distinguishment between frequently asked questions being maybe an indication of intent, but certainly not law that we could rely on at this point.
Yeah, so, if I look back when the last Tax Act passed, not the CARES Act, but the Tax Cuts and Jobs Act in 2017, because it's sort of similar to how the CARES Act is being treated, because this legislation is getting issued and written into law and effective immediately. The process through which legislation gets issued, whether it be regulatory guidance, is typically a long process. There's a lot of commentary that needs to go on, and in the public, and so in the interim, they issue these FAQs, which drive where that regulatory guidance will go. But it's certainly not effective law, if you will. But it is, if you're relying on the FAQs as your guidance, you're acting in good faith. There's no doubt about that. But I do suspect once the actual regulations get issued, it will be a little bit more in detail. At least I hope. We'll see. It's been, up until last week, the guidance that was coming out was pretty fast and furious. And it's slowed down a bit since then. And we'll talk about a few reasons why I think that is. But just sort of continuing on with FAQ for a couple of minutes, I think going back to these loans over $2 million and looking at what type of documentation you should be sort of gathering and including to make sure that, you're presenting your best foot forward in the event of an SBA review, looking at if you would have made different business decisions if you weren't going to have this loan forgiven, I think that will be a key factor that you can present to the SBA and say, hey, look, without this program, I would have in fact laid off however many people, and I didn't because I had this program. Or without this program, I would have done, XYZ different. I think that those are pretty compelling. That's pretty compelling documentation. The SBA cannot expect that the business owners are making business decisions retroactively. We don't live in that space. So I think anything you can do to sort of provide that story for the SBA, the better off you'll be. Tim, now it's probably a good time for you to sort of talk a little bit more about what you think some of the good ideas as far as that documentation support, what they should be considering.
Sarah, before you switch gears there, just one question. So a couple people are asking if, so now that this new FAQ is out, if people have already given money back and they're less than $2 million, what's their best course of action at this stage?
That's a tough question to answer. You know, I would say to still gather that documentation support that we're going to talk about to provide the basis of, you know, why you need that loan and that certification. But unfortunately, I don't think you're going to sort of fall under this category of having an original principal balance of less than $2 million. And you still need to prepare yourself for an SBA review.
Okay. Anything else, Ben? So like Sarah said, I mean, our objective here, even with a lack of definition, and frankly, without reliable law that would say absolutely you're going to fall within this range of forgiveness, or the fact that we now may have some indication of their intent to avoid criminal or more robust repercussions for this loan. We think it's important that you consider what should you be documenting from the day this law was proposed till now. What are the things that would basically create the story or the information necessary to meet that standard of good faith and necessary? Okay, so some of the things that we put together, and I think we're going to have this list will go out in a blog, I think, later today. But consider all your communication with your customers, your vendors, your employees, your bankers, your accountants, your attorneys regarding uncertainties. And that is as broad as you think it is, from a customer delaying a job start, from a customer asking you to consider longer payment terms, supply chains delays that you're already aware of or that have already been communicated to you. Maintaining that documentation is going to be very, very important. Loss of key employees, and there's a couple categories there, and some of this may factor, frankly, into the end calculation of your full-time equivalents. But have you had employees that have been infected or their families been infected? How did closing of the schools or the stay-at-home order impact your business? Those are all factors that impacted your business and your decision, your good faith decision to determine that your loan was necessary. Loss of efficiencies due to workers working remotely. So for those of you who maybe aren't making something in your plant where your business was essential, have you, like Clayton and McCurvey, have you set your workforce working from home? And obviously there's an impact to the efficiency of being able to work in the same office versus working remotely. Your overall length of cash flow cycle, what's happening? Like I said before, are your customers asking for different terms? Are your vendors asking for different terms? Is it affecting rebates, discounts, all the factors that affect cash flow or that could impact cash flow in your business? Thinking about your bankers, how is this impacting your loan covenants? Now, you may be fine cash-wise, but if your customers are delaying payment, you've got a borrowing base formula, and this could significantly impact your ability to borrow. Maybe you've got tainted receivables over 90 days, and maybe you haven't asked your bank to extend those to 180 yet, but those are going to be factors that affect your business. You know, the pandemic is affecting your business in, like we keep saying over and over again, in different ways. And looking at your loan covenants or your borrowing base formulas, how do those impact your business, especially if you weren't anticipating additional needs for borrowings? You know, that's another key factor. Had business gone on as usual, did you have forecasts for your business that put you in a position where you wouldn't need bank financing, and now you're in a position of needing bank financing? I think you should consider your budgetary process. Did you have a business? Did you have the infrastructure and the manpower to work at a certain level? And now with either delays or deferments of jobs, is that infrastructure sitting there either idle or not fully utilized? There's an impact to your business. And what about the added debt that you might incur? If this loan is potentially deemed unforgiven or unnecessary, what debts would you have to incur to keep your business going, and how would they impact the future operational effectiveness of your business? And the last couple of items here, how has what I call the best practices of COVID-19, meaning what have you had to implement in your business, whether you were deemed essential and had to put thermometers in place, sanitation stations, all those different types of PP&E that you had to implement in your business, clearly that's an impact to your operating if your business has been essential. Have you had any complete or partial shutdowns? I know for some of our clients, part of their business was considered essential and part was not. And so that played a role in determining, well, do we still maintain the same employment levels that we had before the pandemic? Do we continue those even though only part of our business is considered essential? And the biggest one for those of us here in Michigan, that is, you didn't know day to day what kind of mandates were going to come from the state. So to be able to document the phases that we've gone through, and now I think we're in phase 3 of our recovery, but think about all the various changes almost every day that were implemented by our governor with respect to staying at home, determining what businesses were essential. So that's kind of our preliminary thought, or at least a kind of a synopsis of what are the kind of things you should consider documenting the necessity of your loan. And I will say this, that we are going to put this list out so you'll be able to refer to it. But I also think it's important to not just look at what's happened, but also what potentially could happen. You're still having to go through these discussions right now. And I know there's still funds available. So some of you are still contemplating this, but thinking about the state increasing their restrictions, or thinking about if your business was determined to be non-essential. I think we've all locally read the reports about these drive-ins that have tried to start and were determined to not be essential. We've seen the golf courses go from non-essential a recreation to ability to have recreation. So thinking about what could happen is equally as important as what has happened when you're documenting how the pandemic has affected your business. That's it.
Okay. As my screen tries to share again here.
All right.
I'm just going to sort of jump back into, I don't know if it's up or not again. No, it's not. But if we talk about a couple other things while that's thinking, that have gone on that maybe will help us drive where we think some of these other questions, especially as it relates to loan forgiveness and some of the other outstanding issues that we talked about last year. There's a few important things that have happened in the last week. And while it's not guidance, I think it will drive guidance. And I also think that it is driving the slow pace of guidance that we've seen. The biggest thing that has happened is the SBA's Inspector General completed its first report. And while the report concluded that the interim final rules and FAQs that have been issued mostly align with the act, there were a few exceptions. And those are some pretty key exceptions. The first and last ones in this list I'm not really going to talk about because I don't think that they're that important to the audience here. The two big items are loan proceeds eligible for forgiveness and the guidance on loan deferments. Essentially what the Inspector General found is that the guidance that was issued that placed the restriction that 75% of loan forgiveness amount must be related to payroll costs didn't align with the allowable use requirements included in the CARES Act. And in their commentary, they also said that many businesses have higher operating costs than wage costs, and this rule was adding an extra burden that wasn't actually intended in the legislation issued. So if we reflect back to how this guidance has gotten issued, it's been an interim final regulation that has yet to go through public commentary. And so generally when regulations are issued, there's a 30-day public commentary window before they go on to the next level and actually become part of federal legislation. So this isn't an area where Congress would need to change the legislation. This is an area that could get fixed as these final regulations become final regulations rather than interim final regulations. I've heard some discussion happening within congressional circles that some want to open up this restriction on loan forgiveness, but potentially only open it up to certain industries, such as those that are not yet open. If you think about restaurants, hair salons, nail salons, those types of industries, who typically also have higher overhead costs and lower wage costs. I don't know where it will end, but I think that report that the Inspector General of the SBA saying that this is not congruent or not aligned with the intended legislation is pretty telling and could have a positive impact on where this future guidance goes. The second item that they found overly burdensome was this 2-year repayment term. When we reflect back to the CARES Act allowed for a maximum term of up to 10 years. And when the Treasury and the administrator issued the interim final rule on this, they came back and said, we think that a 2-year term is sufficient based on where this pandemic is going. I think hindsight being 2020, nobody really thought the pandemic was going to last, the shutdown was going to last as long as it has. So I wouldn't be surprised to see some change in this guidance. I think the issue with that will be that everybody signed their loan documents already, and those loan documents come with a 2-year repayment term. So I think there are some hurdles to changing that guidance. I don't know what that would look like, but those items are out there. The Inspector General is saying we don't really agree with the guidance that's been issued to date. Would not be surprised to see there be some additional changes made. The other thing that's happened is last Monday, Secretary mentioned, all of this talk with what's going to be deductible and what's not going to be deductible. The IRS issued the rule that said your expenses, to the extent you've had PPP loan forgiveness, your expenses won't be deductible. And there was a lot of discussion, is that the right conclusion? And Secretary Mnuchin had came out and said that he agreed with the guidance that the IRS had issued. He's now saying he's open to some technical fixes if there's bipartisan support to do so. I will say also that in the HEROES legislation that was just proposed or introduced yesterday in the House of Representatives, there is a technical fix to this issue. And in that legislation, it expressly states that those expenses will in fact be deductible and will not be subject to the code section that the IRS has sort of quoted as why they will not be deductible. In addition, there's congressional discussions with the IRS right now. They're trying to get that rule changed without legislative guidance. They're trying to actually just get the IRS to change that notice that in that conclusion that they've come to. And there's some reasons behind that. I think there's a lot of talk that maybe the code section that the IRS quoted doesn't actually apply to this. The legal interpretation in code section 265 talks about wholly exempt income. And so there are some people out there saying that, well, wait a minute, a PPP loan in and of itself is not wholly exempt. And in fact, it may result in no forgiveness or only partially exempt income. And code section 265 doesn't apply to that type of income. And so there's a little bit of talk, hey, maybe the IRS has its own authority to come out and say, we've misinterpreted the legislation, and they can backtrack on that notice that's been issued. I think that in the end, that we will end up that these expenses are in fact deductible. I'll be pretty surprised if that's not what happens. So that's where we stand on what's the deductibility of these expenses. We're still stuck with the IRS notice that exists today, but I think there's going to be more forthcoming that will be positive for the taxpayers and the borrowers of these loans. A few other things that have happened recently, and I think some of this is driving why we didn't get the guidance that the SBA had sort of promised before tomorrow on the loan forgiveness or the certification, the good faith certification. there was a lawsuit filed against the SBA regarding the eligibility requirements that were issued in FAQ 31 and 36. It specifically, went after the SBA to say, this isn't fair. You guys are imposing hindsight. We made a good faith certification. We should not be expected to draw down on our line of credit or use our excess cash reserves that we've been, sort of saving up for additional capital improvements or capital investments. That would be detrimental to our business. We don't know what this means. And so there was a lawsuit filed. And it's pretty telling that the company that filed that lawsuit, they had a combined, it was 3 companies that were related, and the combined loan was only $750,000. So they weren't even in that category of they would definitely be reviewed by the SBA, but they went ahead and filed a lawsuit anyways. I'll be surprised if they don't rescind the lawsuit, but we'll see where that goes. They may, in fact, continue on with the lawsuit just to be the first to do it and try to get some clarification on for everything, or if nothing else, help drive where this final guidance in fact goes. And then, the other thing that's happened in the last week, and I got a few phone calls from clients saying, whoa, I heard that people have been arrested because there's been fraud against the PPP Loan Program. Is this something I need to be concerned about? And the answer is no. This fraud case is in fact real fraud. It's not related to questioning the certification. You had a couple of guys out in New Jersey who owned some restaurants that were closed before the pandemic started. They filed for a PPP loan claiming that they had dozens of employees, and so they had payroll qualified for the PPP loan. It was found after the fact that they in fact had 0 employees. And in one case, one of the applicants even used he used his brother's identity to apply for the loan because he'd actually been convicted of a felon and he was not eligible to get a loan. So this was a true fraud case. It has nothing to do with the certification. Are committing, what we would traditionally consider fraud, you should not be worried about that case at this time. Tim, Ben, are there any questions so far? Is that a no?
I was on mute, so I do have a question from the audience, and it relates to Sarah. I think we had this one maybe in the first week and maybe in the initial discussions of the loan, where I think some people were receiving recommendations about setting up their PPP funds in separate bank accounts. And the question directly is do you need to trace dollar for dollar? And I wonder if you share your thoughts. I have some thoughts on it as well, but why don't you share your thoughts about, we have this intent of forgiveness, we have the intent of use of funds, and so why don't you share what your thoughts are on actually tracing dollar for dollar for qualified expenses?
Yeah, my thoughts are, to the extent you can do it, the better off you're going to be. The better off you'll be able to put that application together to apply for the loan forgiveness. We don't know what the process actually looks like yet, but we do know that there is going to be an application process to get loan forgiveness, and to the extent that you can trace where those dollars are spent. Now, I have a lot of clients who, may have applied for a loan with a different bank. So their payroll set up to be automatically withdrawn from bank account X, but their PPP funds went into bank account Y. And to change your payroll bank account sometimes takes, 10 business days. And then there's the added hurdle of some of your payroll costs aren't qualified costs. So do you really want to do that? Can you just use the PPP funds to reimburse your standard bank account? I think that that's okay. I would do it on the same day, and I would track those costs, right? I would track what your qualified payroll costs are and your non-qualified payroll costs, and show that that transfer was only for the amount of qualified payroll costs. Similar to rent, utilities, the other costs that are qualified, I would do your darndest to trace those costs.
Yeah, I think that's a great answer. And I think there may be some companies who are in more of a, perhaps maybe they're shut down but still continuing to pay employees. one of the things that I think will be important if you kind of reverse engineer this is to make sure that if you are paying other expenses, do you have other sources of funds? And that will be important because, if you're paying approved types of expenses, outside rent, utilities, payroll, health insurance, health benefits, you've got other payments you need to be making, principal payments on loans, and you have no other source of funds. You'd have a hard time then explaining how you didn't use those PPP funds for a non-qualified use. So, thank you.
I think as a lot of people are beginning to track these expenses, one of the first questions that kind of come to mind, and I see a lot of questions here in the queue, is kind of going back to our conversation last week too. Is this an accrual-based calculation, a cash-based calculation? And as I'm starting to add these costs in, what really applies here? And I think the answer still remains is that the law says incurred and paid, and we're hoping for some further guidance on that front as far as if I pay employees a profit sharing now in May that's related to 2019, does that really qualify? Is that going to be included in forgiveness? And we just don't know that answer yet. So just keep that in mind as you start to prepare these calculations.
Yeah, I agree.
I think you're on mute.
Much easier to unmute myself when we're in person. It is just so much easier. I was agreeing with you, Ben. There are quite a few questions related to this cutoff, and it's still uncertain. If you go with the incurred and paid, it would at least imply that you can't be grabbing expenses like you use the example, Ben, 2019 payroll, 2019 profit sharing that's now paid in 2020. That still want to track that. There's a chance it's not going to fall into the incurred definition when they finally define that.
Yeah, there's been some discussion about, okay, well, then can I pay my 2020 profit sharing if I'm going to have one, or my 2020 401k profit sharing? And there's been some thought leadership that says, hey, we think some of that will be includable, but we think it's going to be 850 seconds. So you have this 8-week period, and so we will allow 8 weeks worth of that cost to be included, not the full amount. But we don't know where it's going to end. Unfortunately, they haven't issued the guidance yet.
The other thing would be, could it possibly slow down your forgiveness? You've paid an expense in this period, and do you have to wait till you know what your total profit sharing was for 2020 to determine what 850 seconds of that was to determine the forgiveness amount? Just a thought.
Yeah, well, I think you'd have to pay it.
No, I'm saying they paid it, but you wouldn't know the forgiveness amount. They could throw $100,000 into a profit sharing account, and then you gave a great example. 850 seconds of whatever it's going to be would be applicable to that period. You may not know that till December. So. Yep.
And the thing to remember, and this is sort of where I continue to struggle with how is the SBA going to review all of these loans, is that the banks have 60 days to issue a determination on forgiveness. And again, that is in the legislation. That is not in an interim final rule. It is not in an FAQ. It is actually in the CARES Act. Now, they could adjust the CARES Act. They could make an amendment that says, oh, we're going to allow for a longer time to determine forgiveness. But somehow the SBA is going to have to review all of these loans over $2 million to make those determinations. And I still struggle with how they are actually going to have the resources to get that done. I tend to think that some of the guidance that's been issued today is sort of to relieve some of the pressure that the SBA has been under, both with people pressuring them to give us some clarity on what does this good faith certification mean? What are you going to be looking for? But I also think it also gives them a little bit of relief of pressure from the public. The SBA has come out and said that they're going to throw the hammer at people who have taken these funds for purposes, when they didn't need the funds. And that sort of has relieved some of this public outcry of all of these companies are getting these funds and they don't deserve them. And so I think it's going to end up somewhere in the middle. When I go to my next slide, we'll talk about some of the statistics as of May 10th, I guess. And we'll talk about the volume that is out there of how much needs to be audited, but I think it's going to be hard. So if we move on to, am I frozen, you guys?
No, you're still live.
Okay.
We're on slide 8 on my screen.
There we go. Okay. My computer was just frozen for a minute. Sorry about that, guys. So if we talk a little bit about the statistics, last week I'd shown you the statistics through May 3rd. These statistics haven't changed that much. Last week, the second round had approved about $175 billion. So I think a lot of that increase or that lack of increase can be attributed to the funds that have been paid back. All of the funds that were paid back either by public companies or other companies that determined after they received approval that they didn't in fact qualify have been added into, has sort of been netted out of net approved dollars in the second round. So I think that's why we're seeing a slowness. So if you look at this as of May 10th, there's still almost $112 billion available, or $120 billion available for funding still. So if you have, friends that should have applied for the loan but didn't, they were too uncertain, there's still time. We thought that these funds were going to be exhausted by now, and we're sitting here and there's still a fair amount left. If we look at the statistics, the average loan size in the second round has continued to decrease as time has gone on. So last week we talked about it, it was 73,000 or 76,000. It's now down to 73,000 is the average amount of the loan in the second round. In the first round, it was $206,000. Pretty telling that, the bigger companies with the most access to resources and obviously probably stronger banking relationships were able to get quick access to the funding in the first round. But again, when I look into the detail of these statistics, there's about 40,000 loans out there that are over that $2 million mark. And so that's 40,000 loans that the SBA has to review within 60 days of application. I did read something that said that they are expecting the banks are going to start accepting loan applications in week 7 of your 8-week period. So I don't know if that's true. It'll be difficult, especially for those that got funding really fast, because nobody has any guidance on the loan forgiveness yet. So I guess TBD on that topic right now. So if we sort of recap what is still unknown, it's still a lot of the same things from last week. All of these definitions are still unresolved. We still don't know, is this cash basis or accrual basis? We don't know the definition of incurred and paid. We still don't know the definition of rent. Is it just real property? Is it real property and personal property? If you have a lease that includes, CAM costs, are those included as your rent? We still don't know these answers. Unfortunately, I don't know when we'll get those answers. We still don't know how self-rental will be treated. We still don't know the definition of covered utilities. Specifically, we don't know what transportation costs are. There's thought that it is fuel for trucking companies, but that's sort of just speculation at this point in time. That's not actual. There's no guidance that tells us that for sure. We don't know if the definition of mortgage interest will only cover real property, or will it cover real property and potential personal property. And then, still all of those definitions surrounding payroll costs that we've talked about in previous weeks. I think we still need some clarity surrounding the covered period. All of this stuff hopefully is forthcoming. We'll certainly let you know as soon as we know where that's going. Tim, anything to comment on that?
One of the things that's consistently coming up in here is rent for cars and other things. And I think I think it would be important to say, I think the only qualifier for rent is that it be a lease in place on February 15th, 2020, to be a qualified use of funds and qualify for forgiveness.
Yep, it's
So-
just, we don't know if rent includes personal property, right? So if you have a forklift lease or car leases,
Yeah.
printer
And-
leases.
And thinking ahead to definitions, having those leases in hand might be important. So if you're self-rented, Sarah's bringing up, how is self-rental treated perhaps on the forgiveness side, but how about self-rented and you don't have a lease, you're month to month? So it may be something that you need to sit down with your attorney and determine what was your status on February 15th, 2020. Okay.
Yeah.
A few questions on, can I prepay rent as well? And I think that goes back to your earlier point, Sarah, about incurred and paid, where again, cash basis versus accrual, we don't know yet, but there's a good chance that it probably needs to be incurred during that 8-week period for it to be qualified forgiveness costs.
Yeah, I think so. So a few items that we wanted to clarify, we got a lot of questions on these in the last webinar, and so we thought that they were worth a little bit of extra attention today. There's a lot of confusion on this 75% rule, right? And we got a lot of questions that said, if I don't use 75% of the total funds on payroll, does that mean I don't get any forgiveness? And I think the key phrase in this part of the guidance is for complete forgiveness, right? It doesn't say for any forgiveness, it says for complete forgiveness. And so if you look at it and say you have $1 million loan, and we went through this example in the very first webinar, but if you have $1 million loan and you have only used $800,000 of those funds in your 8-week period, you will only be eligible to receive $800,000 of forgiveness. The other $200,000 that went unused will turn into a loan. That's this 8-week period that people keep talking about. You have only 8 weeks to spend the funds. And one of my clients said, it's like Brewster's Millions. Like you have 8 weeks to spend the money. And then when you look at that $800,000, so that's your eligible pool of loan forgiveness, then you look at it and say, did I spend at least 75%, or in that case would be $600,000? Did I spend at least 75% of that on payroll? And if you didn't, to the extent you did, that would be the amount of your forgiveness. So there is some eligible that will go into play. There's some computations that you'll have to do, but it's important to remember that it's not 75% or you get no forgiveness. That's what's going to drive your forgiveness. So if you look at how much you spent on payroll, divide that by 75%, and that's how much you'll end up getting forgiven, assuming that these other FTE and compensation reduction rules aren't applicable to your situation. When we look back at the FTE reduction rules, a few things to remember, right? There's 2 periods that you are allowed to look back at. And it's the borrower that gets to make that election. So you want to make sure that you understand what those periods are and that you elect the period that is best for you. And those periods are February 15th, 2019 through June 30th, 2019, or January 1st, 2020 through February 29th, 2020. And so when you look at your average FTEs for both of those periods, you would probably want to take the lower and use that to determine whether or not you have any FTE reduction rules. Now, we got a little bit of clarity around, employees who declined to rehire, employees you've offered rehire, but they've declined and intend, either they found another job or they intend to stay on unemployment. FAQ number 40 offered us some clarity on that and said, hey, if you have written documentation that you offered to rehire that employee and they have rejected that offer, then you will not have to reduce your FTE. You won't have that won't count against you for this reduction rule. But there are still questions out there. What if you had an employee who retired sometime during the period of your base period or has retired since? Will that still count against you? Retires during your 8-week period. Will that still count against you? What if you have an employee that dies during that period? Will that person count against you? We don't have clarity on that. My hunch is, based on how they've handled this rehire rule, is that they'll carve out some exceptions for those types of events. But until we get that guidance, we just don't really know. Tim, I'll let you talk a little bit more about your thoughts on the FTE reduction rules and the compensation reduction rules.
So really good points on the full-time equivalent reductions. I think it's important, especially now, since the look-back periods are defined, those are historical, to put your full-time equivalent calculations together. And in my opinion is to identify those nuances that Sarah described. Understand which employees maybe have retired within that period. Has anybody passed away? Has anybody fall under the Family Medical Leave Act? Do you have employees that haven't been able to come back to work because either their own infection of COVID or COVID within their family? Sarah gave the example that was addressed in question number 40. If somebody decides not to come back to work, but then what about somebody who just quits or retires? So I think making sure when you put your full-time equivalent database together, identify those nuances, because we do think if question 40 is any indication of the intent is to not punish you for somebody who has no intention of coming back to work for you, and you haven't been able to fill that position. And that's the example of question number 40. On the payroll reduction side, this is where maybe I'm stepping outside over my skis a little bit. So this is where law and terms get really tricky, and I think it's important. Let's start with the simple one. We've had this question happen before. There's a certain amount of algebra that we think is confusing at best, and that is the fact that we looked at a 12-month period. Likely either you used 2019 or you used a trailing 12-month period to determine what was your average compensation, to then do 2.5 months times that to determine your borrowable amount. Now we get to this 8-week concept. This covered period is 8 weeks. Well, 8 weeks isn't necessarily 2 months. 2 months isn't necessarily 8 weeks. So it's come up more than once. One of my partners was on another seminar where they brought up the fact that, well, I was able to borrow 2 months of 100,000 at 16,666, but now when I do the forgiveness, it's only 8 weeks, which is 15,384. Yes, I mean we're not proponents that this is rock solid and everything lines up and months convert to weeks easily, but we at least want to address that is there's going to be some algebra in your annualization of somebody's pay to determine their $100,000. There might be some annualization or a different denominator that you have to use if somebody's only working in that 8-week period, but they do fall into that plus $100,000 category. You may not get the full 15,384 if they've only been on payroll for 7 of those 8 weeks. You may have to take 7/8 to determine what's the right amount of compensation they could have earned in that period, so you don't inadvertently put into your forgiveness formula an amount that was greater than the intended cap of $100,000. The last two things get a little bit tricky. I'm looking at my colleagues here because the words that the government uses in this law can at times maybe be used in your favor. And one of the particular items is when you're determining if somebody's compensation has been reduced. Well, the concept, which is in the law, has been anybody who makes over $100,000, you don't put them in that category. You're not looking at them in this formula. You're looking at everybody who made less than $100,000. But one of the items within that calculation, and it's specifically called the reduction based on the forgiveness or the reduction of salaries and wages. Well, they're bringing up the issue that if an employee in any pay period earned an annualized equivalent of $100,000, greater than $100,000, you would not include them in that formula. Now, I brought this to Sarah's attention earlier, and we had a discussion about it. This could essentially mean that there might be more employees you could exclude from that calculation. Let's face it, that calculation's only purpose is to determine if your forgiveness needs to be limited in some way. And the fewer employees you got to consider in that calculation, it's likely the better. I'm just going to tell them, Sarah, what you and I talked about, which is it may be that's the specific language of the law, but they really meant someone whose average compensation is essentially $100,000 or that. Not was there one particular period where maybe you had a salesman who got a commission, maybe you had employees who make a decent wage, but all of a sudden got a lot of overtime in a week. Could that possibly negate them from this calculation? I'm going to say we're not sure. The law reads pretty black and white that it says if somebody earned an equivalent or an annualized amount greater than $100,000 in any pay period, you would not include them. So just kind of throwing that out there. I think it'll be one of the things that maybe gets addressed hopefully further down the road. Sarah, do you want to mitigate what I said, or?
I don't want to mitigate what you said, but I do want to clarify that, because you're saying that person would not get included. But I think the key is that the amount of that weekly compensation that would annualize to greater than $100,000 would not get included.
What I'm saying is that if at any time their compensation for that pay period annualized greater than $100,000, that person would not be included in the wage limiter calculation, is what I'm saying. That's what that limitation is. And I'm watching your eyes. I'm watching your brain work.
Yeah, it's not working fast enough.
Well, maybe we'll address this one in a further point. But there is one other, again, undefined aspect of determining the reduction for salaries. And it says you're supposed to look at the most recent complete quarter that somebody worked. When you're comparing what did they earn to what did you pay them during your covered period, right? So they use that specifically, the most recent full quarter during which the employee was employed. What we're not sure about is that a calendar quarter, which would be consistent with how most people file payroll tax returns, or is it a trailing quarter, or the most recent 3-month period that someone worked? That is uncertain, but obviously we would need to know that to determine what is the benchmark for calculating somebody's payroll reduction. So two uncertainties in that: what is defined as the most recent quarter where they had full employment, and is it possible to exclude any employee who earned an annualized equivalent in any pay period greater than $100,000 from the payroll reduction? That's a lot, I know. I'm watching two smart people look at me like I'm an alien.
We're running up out of time, so I'm going to move forward and sort of get to our conclusions. I will say that I did tell Tim that I think that he's going to bring stuff up that's just going to muddy up the waters even more. and I think he did. Bless me. I mean, at the end of the day, I think, it's pretty clear. We got a little bit of reprieve from the SBA today for those loans under $2 million. I think people can sleep a little bit better at night knowing that they feel comfortable with their certifications. There's still some questions around those loans over $2 million and what the documentation is that's going to be needed. We certainly are dying for the loan forgiveness guidance. I think Tim and I look almost every day, 10 times a day. I'm constantly refreshing the page that it's on. We'll certainly send that information out. If it comes in, tomorrow, we'll hold a special webinar for you guys to get that information out more timely, so you're not waiting a week. If we get an interim final rule for the certification for those loans over $2 million today, we will hold that 3 p.m. webinar tomorrow to give you guys our information on what that means. And
sir, I just want to be clear, because I didn't say this earlier. I asked people to save the date, but Denise popped a question in there, and hopefully people read it. We will send the same invitation out. So we will proactively send out the invitation to make sure people know we're having the webinar.
Yeah. If you don't get an invitation, assume that there has been no guidance. It would be the safe assumption. We'll keep you posted as we have been all along, and certainly we'll stay on and respond to the questions that are here that Tim and Ben didn't get to during the presentation, so that everybody knows where we stand on what your questions are.
All right.
Tim, any other
Nope.
lasting thoughts?
I just want to wrap it up, let everybody know myself, Ben, Sarah will continue to answer questions. We've noticed many of you hang around and watch that. We'll try to behave ourselves. I think on the first one, I may not have behaved myself. There's a broad spectrum on not behaving myself, but so we will.
Good for you, Tim.
Yeah, we will continue to answer your questions. And then these will ultimately get posted and released out along with the webinar. I did see some people who, while they couldn't hear us or see us, were somehow able to type in a question and let us know they couldn't connect. And so obviously, hopefully they'll be able to watch this through a link on our website and frankly, a link to the participants to be able to share this or listen on. At the very least, we will look forward to seeing everybody next Wednesday at 3 o'clock. And perhaps even as soon as tomorrow. So I guess in consistent with my welcome theme, I would say adios, ihorjin abiento, and we'll see everybody soon. Hopefully next Wednesday. Thank you.
Thank you.